Your Lordship. I picked a mention supplementary item number 33, Your Lordship. I will the manner may be listed on 17, Your Lordship. 17, yes.
33.
Yes, Lordship.
You want this to be listed on 17?
Yes, Lordship, 17. As fixed item, Your Lordship. As fixed item. 17.
Okay.
In the meantime, Your Lordship, interim pastor may continue, Your Lordship. 33.
Mr. Supamati, involving land counsel for the petitioner, prays for listing this matter on 17
As fixed item, Your Lordship.
as fixed item. Mr. Jumomi, planning government advocate, has no objection. Start now. Is prayed, list this matter on 17. Start. In the meantime, the interim order passed earlier shall continue till then. Okay.
Obliged, Lordship.
May I please, Lordship? Lordship, I beg to mention hearing item number 21.
21.
Lordship, if this matter can come up after 2 weeks, Lordship. 21. I have taken the consent.
Okay. Mr. Jimami, land council appearing for the state.
For the state.
With the consent of the land council for the petitioner, the applicant prays for listing this matter after 2 weeks. The prayer is allowed. List this matter after 2 weeks. Okay.
Lordship, I beg to mention item 1, 12, 13, and 26. Item number 1, 12, 13, and 26.
26.
Yes, Your Lordship.
In all the cases, you are for the petitioner.
For respondent.
In all the case,
Yes, Your Lord.
you have taken the consent of the petitioner.
I've taken the consent, yes, Your Lordship.
Item number 1, yes.
Item number 1.
Yes. For item number 1, yes.
Okay.
Lordship, item number 26. I'm for the petitioner. Lordship, matter pertains to compassionate appointment. Instead of considering the case of the petitioner, whose husband expired in the year 2014, the order of respondent number 7 was expired, who expired in 2017. His case was considered, and the matter has been pending since 2022. Now, the respondent 7 is illegally holding the both, Lordship, without considering the case of the
Private respondent.
Yes. Therefore, there is urgency, and on several occasions the matter has been fixed, but in one or the reason.
That was also considered on compassionate ground.
Yes.
No, that one, the
Yes.
respondent also. Okay.
R7 was also appointed on compassionate ground.
Okay, when do you want, you said? Okay, I to one by one, huh? Let us take. Miss.
Cricket.
In fact, it's a short matter,
Hold on
Lordship.
just a minute. Okay. Land council for the respondent, you are for respondent. On the consent, with the consent of the land council for the petitioner, Mr. Petitioner, Mr.
On behalf of Akin Yusuf.
Okay. Praise for listing this matter on after
3 weeks, Your Lordship.
3 weeks. The prayer is allowed. List this matter after 3 weeks. Then let us come to item 12. You say 26. 26.
Yes, Your Lordship.
Okay. So
3 weeks, yes.
Lordship, a short time may be
Okay.
given, Lordship.
Miss again, huh? Our counsel for petitioner, sorry, respondent.
26.
Here in 26, you are for respondent.
I'm for respondent number 7.
7 is a private respondent.
Yes, Your Lordship.
Okay. Praise for listing this matter after 2 weeks.
Lordship, let the matter be fixed on 14.
14, is it
Yes,
okay?
there is urgency, Lordship.
Yes, Your Lordship.
All the bleedings are completed.
Okay. Then, and then on the joint prayer made by the Lana Council for the petitioner and the respondent. List this matter on 14th for hearing. Okay. Then item 5,
For 12 and 13, Your
so
Lordship.
12 and 13. You-
Yes, Your Lordship. Your Lordship, for this, 4 weeks time will be given, Your
You're-
Lordship.
Here you are for,
Respondent number 6, we are yet to receive some documents, Your Lordship.
so who are for the
Your
petitioner?
Lordship, I'm for the petitioner, 12 and 13, my lord. This is to do with the removal of the petitioner as the chairman of the village council
Okay.
and the subsequent removal also as a member of the village council.
Mhm.
So your lordship, village council is for a limited tenure. So I do not object, your lordship, but it is my sincere request, both before the zoning court as well as for to the council for the respondent,
Hmm.
that this matter may kindly be taken up seriously, that on the next date, affidavit may be filed.
You have not yet filed affidavit.
Yes, Your Lordship.
You file affidavit by the next date. Miss. You have a respondent number 6.
Yes, Your Lordship.
Okay, Land Council for the respondent number 6. Pray for further 2 weeks' time to file affidavit. Mr. Joshua, Land Council for the petitioner submits that this may be a last chance given to the Land Council for the to the respondent for filing affidavit stuff. As prayed, the case stands adjourned. List this matter after 2 weeks. Okay.
Bless you,
I
Lord.
bless Your Lordship.
Lordship, I beg to mention hearing item 19, Lordship. Here, issue number 10, another additional issue has been framed by this honorable court and the same has been sent to the trial court, Lordship, for settling the issue. Now, Lordship, the plaintiff's counsel, who is the counsel for the appellant here, is under bereavement. And Lordship, which is why the examination of the cross-examination of the defendant number 4 has been postponed till 14th of June 2024, Lordship. Therefore, I pray
This
that
item 19
item 19,
is
Lordship,
for hearing.
item 19.
Hmm.
So I pray that the matter may be listed in the month of July, Lordship. Because cross-examination before the trial court shall be
You are
conducted
for?
only on 14th of June.
You are for?
I'm for the state, Lordship, for the forest department.
Okay, who is for the petitioner here?
The petitioner,
Applicant-
Lordship, he is under bereavement, Lordship.
Appellant, huh? Okay,
He is under bereavement. He is from Gauhati and then
okay,
this is a consensus prayer, Lordship.
okay. On the consensus prayer made by the land councils for the party, list this matter
In the second week of July, Lordship.
in the second week of July. Okay.
Deeply obliged, Lordship. Lordship, I also beg to mention item 20, Lordship. Here also, Lordship, I am for the petitioner, but the opposite counsel,
Item,
item 20, Lordship.
okay,
For respondents 2, 4, and 5, he has some personal difficulties, Lordship.
okay.
So if it can kindly come up after 3 weeks, Lordship.
For the respondent 2, 4, and 5, Your Lordship.
Okay. So it is a prayer of respondent.
It is a consensus prayer,
Yes,
Lordship.
okay.
Yes, yes. My learned friend, he has some personal difficulties, Lordship.
On a prayer of the consensus prayer of Mr. Santiago, Land Council for the petitioner, and Mr.
Chuba.
Land Council for the respondent number 2 and 5. List this matter
After 3 weeks, Lordship.
after 3 weeks.
Lordship, there is an interim, if it may
Stop.
kindly.
The interim order passed earlier shall continue till the next date. Okay.
Much obliged.
Marvelous, Lordship.
Yeah.
My Lordship, this item number 21, this is already mentioned in my absence. So there is an interim order. So I pray that interim order may continue till the result of the date.
Okay, so Item 21.
21.
So the interim order passed earlier shall continue till the next stage. The interim order passed earlier shall continue till the next stage. Item 21.
Marvelous, Lordship.
May I please, your lordship?
Yes.
Lordship, item number 15. Today I'll be filing my affidavit, so kindly,
Counter noted file. Yes.
15, so kindly come up this matter day after tomorrow, Thursday.
Okay.
Lordship, if Mr. Kindly come up on Monday, I may also,
Okay. Mr. Sentiang allowing counsel for the petitioner is present. Stop.
on Friday.
Mr.
Lordship, it's Friday.
Friday, lordship.
This Friday.
Yes, my lord.
Okay. Allowing counsel for the respondent. Your
State,
or
yeah,
state
lordship.
respondent. Some is that he is filing
Affidavit today.
counter affidavit today itself. And prays that this matter may be listed on
Friday.
Friday. The prayer is allowed, list this matter on Friday accordingly. Okay.
Deeply obliged.
Fabulous, Lordship. I beg to mention item number 8, 9, and 10. Lordship, I've received the counter file by the state respondents this morning. 8, 9, and 10. Analogous matter, your Lordship. I repeat that 4 weeks may be granted for filing affidavit in reply, your Lordship.
Okay. You are for the petitioners.
Yes, Lordship.
So the respondent has filed
The state respondents have filed it.
affidavit.
Yes, Lordship, and all the 3 writ petitions.
Okay. And so what your prayer is,
So I may be granted 4 weeks to file affidavit in reply.
okay. Mr. Walling, Supermati Walling, Lana counsel for the petitioner. Prays for how much time?
4 weeks, Lordship.
4 weeks time to file affidavit in reply to the affidavit. Affidavit in opposition filed by
The
the
respondents.
state respondents. The prayer is allowed. List is mirrored after 4 weeks and
Maybe,
their present may be recorded.
My apologies, Lordship. Lordship, here in item 8, our name is not reflected, so if it can be reflected, our name can be reflected.
Hmm?
Our name is not reflected in item number 8, Lordship. We
Okay.
are appearing for respondent number 7 in item 8, 9, and 10, Lordship. And we have already filed our opposition, Lordship.
Okay, you're for respondent number, state respondent,
Oh, no, Lordship, private respondent 7.
private,
Yes, Lordship.
okay. Miss Anema, Lana counsel for the appearing on behalf of respondent number
7, Lordship.
7 may be reflected in the cause or cause list as the Lana counsel for the respondent number 6, respondent number
7, Lordship.
7, okay. And you are representing state, okay. Miss So-and-so is also present on behalf of the state respondent, okay. Then that is in 8, and in 9 also,
Lordship. Yes, Lordship. 8,
Nine.
9, and 10 for respondent number 7 in all the
7,
items. Yes, Lordship.
and then here also, our name may be reflected, same,
Obliged, Lordship.
May I please, your Lordship?
yeah.
Lordship, I beg to mention item number 2, Lordship, on behalf of Tiba, Lordship. If this matter can come after 3 weeks, Lordship. No, 2.
Affidavit not yet filed.
Lordship, here I'm yet to receive the latest status report, Lordship.
So the earlier you submitted that the matter is under consideration,
Lordship.
okay. Miss
Told you.
Lana counsel for the petitioner is present, and Miss Lana counsel for the state respondent. Some is that they are yet to receive. No, she is yet to receive instruction. So, no, earlier you submitted that the matter is under consideration. How do we record?
The latest status report, Lordship.
Okay. Receive about the latest status report and praise for some more time. Prayer allowed. List is matter after
3 weeks, Lordship.
3 weeks. Okay.
Lordship, I also beg to mention item number 22, Lordship. On
Three?
behalf 22,
22,
Lordship. On behalf of Tiba, Lordship. If this matter can come up after 3 weeks, Lordship. Pleadings are complete, Lordship.
So any
My lord,
objection
if this can come up next week,
next week?
Yes, my lord, the counsel for the state, he called me up this morning and said that he'll take time for a week only. Not 3 weeks. And this has some urgency.
But I was instructed to seek for 3 weeks, lordship.
Okay, so Mr.
Takakichu.
Learned counsel for the petitioner is present. Miss, appearing on behalf of
Tiba,
Hmm.
1, 2, and 3.
the respondent, and you are for
Respondent 4 to 13, lordship.
4 to 13.
Yes, ma'am.
Okay. Miss so-and-so. You are appearing on behalf
On
of,
behalf of Tiba, lordship.
okay, Tiba, learned counsel for the respondent number 1, 2, and 3.
Lordship,
Praise for listing this matter after 2 weeks.
3 weeks, lordship.
2 weeks.
Okay, 2 weeks, lordship.
3 weeks.
2 weeks.
2 weeks, okay. And Mr. Learned counsel for the respondent number 4 to
13, lordship.
13 is also present. Let's break list this matter after 2 weeks. Okay.
Lordship, I also like to mention item number 23 to 25, lordship, on behalf of Tiba, lordship. Hearing item, lordship.
Oh, this is connected matter.
Yes, your
Lordship,
Okay.
after 3
So
weeks,
in,
lordship.
your lordship,
you are in 24. You are in 24.
23, 24, and 25, your lordship, for the petitioner. All the matters,
For the petitioner.
yes, sir.
Okay. So who is praying? Who is praying? Okay.
The object,
Mr.
the
is
government.
present may be recorded. Wabang Learned counsel for the petitioner is present. Miss, appearing on behalf of the state respondent, prays for listing this matter after 3 weeks. The prayer not objected. By the state, no, sorry, the learned counsel for the petitioner. Stop. Accordingly, the prayer is allowed. List this matter after 3 weeks.
Lordship.
Lordship, I also like to mention item number 14, lordship, on behalf of Indi Insong, additional AG, lordship.
14. Who is for the petition appellant? You are for the appellant.
For the petition.
Is your first appeal? Okay,
For hearing was
Mr.
3 weeks.
Learned counsel for appellant is present, and Miss Learned counsel for the state respondent prays for this listing this matter after 3 weeks.
lordship.
The prayer is allowed. List this matter after 3 weeks.
Much obliged, lordship.
Bless your lordship. Lordship, I'd like to mention item 11.
Item,
11. I am representing the state here. I pray that.
counter not yet filed.
No. For filing of the counter affidavit, state
Yes.
counter, I agree for 3 weeks time, your lordship.
Okay,
My lord, let this be the last opportunity.
okay. Mr. You are just. Mr.
Yes, okay.
Learned counsel for the petitioner is present. Mr. Mohammed, learned senior government advocate. Prays for further 3 weeks time to file counter affidavit. The prayer is allowed. List is matter after 3 weeks. Okay. So is there- you want that to be recorded? It's okay. First time, okay.
Obliged, lordship. Lordship, I'd like to mention hearing item last item 27. Lordship, let this matter will come up after a week.
Lordship. No objections.
Okay. Miss Learned counsel for the petitioner, he is present. Mr. Mohammed, learned senior government advocate, prays for listing this matter after 3 weeks.
1 week, lordship.
1 week.
1 week, after a week. The prayer is allowed. List this matter after a week. Okay.
Obliged, lordship.
May I please, my lordship, lordship, I beg to mention item number 4. With the consent of both the parties, I pray for 3 weeks time to file affidavit in reply.
Yes, reply not yet filed. Mr.
Yakasumi,
Learned counsel for the petitioner. How much time you said?
3 weeks time, lordship.
Prays for 3 weeks time to file counter affidavit. The prayer is allowed. release this matter after 3 weeks. Yes. Yes.
From the supplementary cost list for motion, item number 28.
Yes.
May I please, your lordship? It is an application by the state of Nagaland.
Okay.
Represented by the Secretary of the Transport Department.
Hmm.
There is a long history of litigation, but in brief, lordship.
Hmm.
Sometime in 1970.
Hmm.
The Nagaland State Transport Department, they have acquired a big chunk of land measuring about more than 78 acres of land. It is little away from the main capital town because it is the carriage for the Nagaland State Transport where the buses are being parked. So area is a big area. That land has been acquired from the Kohima village and another from 2 villages. It is in the border of 2 villages. It has the land of Kohima village as well as the other village. So it was acquired. Sometime in 80s, one Villali, he is no more, he encroached upon the land of the Nagaland State Transport. So necessary steps were taken. Even the Kohima village people were complaining that, look, we have parted with this land for the purpose of the government, not to be allotted to the private individuals. So if you are to allow to the private individuals, we will take back the land. That was the condition imposed. So authorities were alarmed. And at that point of time, it so happened that one Villali Selitse in 1980s, he happened to encroach to the land of the NST. Since, as I mentioned, area is large, big area. So eviction process started, and then he was about to be evicted, but he filed a suit in the trial court, and an ex parte order was passed. So state government has challenged that, and
State did not contest.
ex parte order, yes, no contest. And the state challenge, that ex parte order was also quashed. Against that, he approached this honorable court. Honorable court directed that since there is a provisions under the law, you go for appeal against the eviction order of the deputy commissioner. So accordingly, the file, no, before that, the approach this honorable court. This honorable court said that no, there is a provisions for filing appeal before the commissioner Nagaland. So you file the appeal. Appeal was filed, that was also dismissed. So against the dismissal order, they have again approached this honorable court challenging the order passed by the commissioner Nagaland. That was dismissed, and liberty was given to the plaintiff, to the petitioner, to approach the civil court. If you are claiming ownership, if you are claiming title, that can be decided only by the trial court by adducing evidence. Therefore, liberty is given to the petitioner to approach the civil court. Pursuant to that direction passed by this honorable court, the present respondent as plaintiff filed a suit before the Civil Judge Senior Division at Kohima, and with a prayer that seeking a direction for perpetual injunction not to disturb their possession and occupation. Not to disturb the possession and occupation. That was the specific prayer in the suit.
Not for title.
Yes. No, not for title. Possession and occupation. And then we filed written statement, and accordingly the trial commenced and the plaintiff has also filed affidavit and the cross-examination of PW1 was also done. And PW2 was about to be examined. During this period, the amendment application was filed before the civil judge, senior division, under section, under order 6, rule 17 of CPC, seeking amendment of the plan. In the amended plan, the prayer made was to issue a direction for declaration of title and ownership over the land. So the basic distinction between the earlier plan, original plan, and the amendment sought is original plan, they have sought for permanent injunction on possession and occupation. In the amended application, they have sought for declaration of title and ownership on the land. So we filed objection, contending that, look, trial has already been commenced and cross-examination was also done. And at this belated stage, the amendment should not be allowed. Secondly, the nature and character and the structure of the suit will be completely changed because earlier plan was for injunction and occupation, peaceful occupation and possession. By filing the amended application, they want to change the entire prior portion along with one paragraph in the plan for declaration of title and ownership. On this point, Lordship, on this point, there is a vast distinction between possession and occupation and declaration of title and ownership. Because possession and occupation may be of any form, in any form. I may be a tenant, I may be occupying, I may be in possession, but maybe without the title. But when the title is granted, entire ownership goes. So title ownership comes along with the title. So they are claiming that in the present suit. And we also raise objection that they were not diligent. Why we are saying that they were not diligent? Because when this Honorable Court given liberty to the plaintiff to approach the civil court, it is categorically mentioned in the order passed by this Honorable Court that if you are claiming ownership and title ownership put word type specifically mentioned in the order passed by this Honorable Court. Therefore, they were very much aware about the title and ownership. But while filing the suit, they have claimed, sought for a relief only for possession and occupation only. Peaceful occupation, that to peaceful occupation. Nothing more than that. Therefore, they were not diligent. And the amended application was filed after about 3 years, after filing the suit. Now, it demonstrates that the plaintiff himself, as well as the court, were not aware, maybe they don't understand what is the distinction, the difference between possession and occupation and the title and the ownership. Learned trial court arrived to a finding that the nature of the suit will not be changed and the plaintiff was diligent. That is the finding arrived by the trial court. If you are diligent, my question is now, if you are diligent, the suit itself was filed on the direction passed by this Honorable Court, where it is categorically mentioned about the ownership and title of the land. They have not mentioned that in the pleadings. They have not claimed that. After about 3 years, they are coming. Oh, we have forgotten to mention about the claim title and ownership. So the plaintiff himself was not clear whether he is the owner or not.
Whether in the first cross-examination to the witness, this question was raised. Probably thereafter they have realized
Yes,
this question was raised.
and the WEs was filed
Hmm.
basing on the statements, pleading.
Yes, yes.
Mentioned in the plain, obviously, because we cannot go beyond what they have stated. That was fine.
What was the prayer there, which was the ex parte order?
Ex parte order.
That petition, what was the prayer there?
In the ex parte order,
Yes,
they have claimed for
title, no,
ownership.
ownership.
Ownership. So they were aware that I'm claiming ownership. But that was, of course, quashed subsequently.
So,
Therefore, Lordship, at this stage, Lordship may call for the records
okay.
and the Indian order may be
Oh.
suspended. Lordship.
State is only a pro forma respondent.
Yes, Deputy Commissioner is the pro forma respondent.
Okay.
The notice may be issued to the respondent, Lordship.
Hmm. Okay. Part Mr. City Jamil, Dana Senior Counsel, assisted by
M.
Dana Counsel
Kumkamia.
for the petitioner. I've also heard Mr. Angami, Dana Counsel appearing on behalf of the respondent number 2, pro forma respondent. Stop. That the case of the petitioner is that after filing a suit and after completion of all the pleadings and procedures, and the trial has already begun, commenced by examining witnesses, the respondent number 1, stroke plaintiff, filed an application under order 7,
Order 6, sorry, Lordship, there is some timing mistake.
order say 6,
Rule 17.
Rule 17 of the Code of Civil Procedure, seeking to amend the plaint seeking amendments in the plaint to include declaration of title to the effect that the plaintiff is the sole and absolute owner in possession of the land, the suit land. Stop. The proposed amendment was opposed by the petitioner stroke defendant on the ground that the defendant number 1 stroke plaintiff was not diligent, and if the amendment is allowed at such belated stage, it would change the nature of the case and would highly prejudice the petitioner stroke defendant. Petitioners. One or how many petitioners?
There are 2,
Okay,
the
petitioners.
secretary and the general manager and his
Petitioners,
team.
defendant. Stop. The said application was heard and reserved for passing order, for passing necessary order.
It was heard on 27/4/2021.
Okay, the said application was heard on 27/4/2021,
And the judgment and order was passed on 26/9/2023.
and by an order dated 26/9/2023, the application for amendment of the plaint was allowed by the trial court after a lapse of about 3 years of after hearing the application. Start. Hence this application start. Issue notice, call for the record. Issue notice returnable by 4 weeks. Call for the record. Stop. Since Mr. Angame, Lanigame advocate accepted notice on behalf of the respondent number 2, within brackets, pro forma respondent, no formal notice need be issued to the said respondent. Stop. The petitioner shall take steps upon the respondent by a registered post with AD within a week from today. Within a week, we'll say?
Yes, within a week.
Week from today. Stop. List this matter after 4 weeks.
Till then, the impleadment judgment and order dated 26/9/2023 may be suspended, Lordship.
Where is the prayer?
Prayer is at page 26. And the interim prayer is at next page, page 27.
Stop. In the interim, it is only because the trial we cannot. It's only with regards to the operation of the said. When it was filed,
Sure.
order was passed on, already passed on 26/9.
Yes.
And if it was allowed, then probably how far it has progressed, because it was, now it's about 5 months.
Yes.
Not 5
Nothing
months.
has been progressed, Lordship.
Now it will amount to the stay of the proceeding itself.
No,
Probably
there's-
they have filed, if it is allowed.
Lordship, that is why.
Thereafter, what happened? You were asked to whether they filed the
They have
amended
filed
petition.
the amended petition.
Already filed.
We have filed objection and that was decided
No.
by the impleadment order.
No, after this application, whether they
Yes,
have filed,
yes. They
because
have
they were
filed.
already allowed.
They have
After-
filed.
After being allowed, whether
Yes.
they have filed the
They have
amended
filed.
petition.
Yes.
And
So-
with,
That will proceed if there is no
no,
suspension.
they have already filed. You have
Yes.
received the copy also.
Yes.
And then you have filed the written statement also.
No.
Not yet filed.
We approached this honorable court. Lordship, what happened? Kindly come to page 19,
Because
Lordship.
it's been now 7 months.
Yes, kindly come to page 19, paragraph 9. Here, some important revelation has been given, Lordship.
Yes.
Has your Lordship got it? Paragraph 9. That the matter was heard on 27/4/2021 and order was reserved. On several occasions, the matter was fixed for pronouncement of judgment, but judgment was not pronounced until the impleadment order was passed on 26/9/2023. The petitioner came to know about the pronouncement of the judgment only in the second week of March 2024, when the counsel for the plaintiff informed that the order was pronounced on 26/9/2023 and amendment was allowed. The said order dated 26/9/2023 was not passed and the petitioner has reasonable apprehension that the order might have been issued backdated. It is also pertinent herein to state that as per the cost list dated 26/9/2023, that is the date of passing the judgment, The matter was not listed on 26/9/2023. All along, the petitioner were in the dark about the existence of the impleadment order dated 26/9/2023. This is what is happening in the trial court, Lordship.
Having regards to the statement made and the statement made in the petition and the submission of the land council, in the interim, the operation of the impugn order dated 26/9/2023 passed in Miss case number 2/2020 arising out of CS number 217 shall remain suspended till the next date only.
Lordship.
Okay.
May I please?
Much obliged.
Lordship, if a requisite copy may be furnished to me so that.
Will furnish
Copy
the
of this
copy.
order.
Yeah, no. The
Yes, will furnish.
The land council for the petitioner shall furnish.
Extra copy of the
Okay.
Yes, one is.
petition.
Okay, then in the earlier order, accepted notice on behalf of so and so. However, the land council for the petitioner shall furnish an extra requisite extra copy to the land council for the state respondent. Okay.
Large Lord.
Much obliged.
For motion item numbers 29 and 30.
May I please, your lordship.
Yes.
Lordship, this instant IA is filed seeking for impleadment of the victim, Shri Kihiton Tap as a respondent number 3 in criminal petition 10 of 23, Lordship, as per the direction of this honorable court, 34/24, Lordship.
Okay. Hard miss.
Mika, Lordship.
Mika HI, land counsel for the applicant. Stop. And also hard. Miss Mary, land, it's a criminal PP, no? Okay, stop. Para. This is an application for implement of Sri Kehiton theft within bracket victim as respond victim in which case?
Lordship,
Victim in
GR 328 of 15, Lordship.
GR
328 of 15, Lordship.
328 of. Where do we find GR case?
Lordship, it's in criminal petition 10 of 24, Lordship. But he is victim in GR 328 of 15, which is pending before the WACA.
Record that one. GR? It's not here. Not mentioned here.
Oh, no, Lordship, I have not mentioned that, but it's in GR 328 328 of 15.
328 of 15, huh?
Lordship.
That's 15.
Lordship, it's a para 2 of my para 3 of my petition, Lordship. Para 2 and 3. The last sentence, Lordship. Page number 4.
Well, the register is PS case number.
Lordship, yes, Lordship. PS case is 5 of 2015, which is
GR, GR number 328/2015, arising out of the PS case number 005/2015. Under section 353, 325, 450, 307, 34 IPC. As respondent number 3, as per the direction of this court by an order dated 30/04 2024. Stop. Is the victim is the necessary party. Stop. The prayer has not the prayer of the applicant has not been objected to by the learned PP staff. Accordingly, the prayer is allowed. Stop. Let Sri, can you have mentioned here?
Yes, Lordship.
Hmm.
Shri
The
Kihitong.
complainant, Srimati. This is Srimati.
Lordship, it's at page 3, Lordship.
Hmm. Yes. Srimati Bikweno M. Merakso, Administrator, Nagaland Institute of Medical Science and Research, NIMSR, Nagaland Kohima, be included as respondent number 2. Stop. The
Be included as respondent number 3 in the main criminal petition, Your Lordship.
oh, sorry, respondent number 3.
Yes,
Yes, Your
Lordship.
Lordship.
It's
Sorry. Okay, not the 2.
yes, Lord 3.
3. Sri, no?
Yes, Lordship.
Sri, can you sing?
Lordship.
Tap, son of Nyabu, resident of Seminyu village, Seminyu, Nagaland, be included as
Lordship, it's Shri Kihitong Tep. That is the respondent, Lordship. The last
respondent.
one. Yes, Lordship. At page 3, serial number, the last serial number 3, Lordship.
Okay, leave that, huh?
LD,
Sri Kehithon,
Lordship.
Tap, within bracket victim, LDA, Office of the Deputy Commissioner, Seminyu, Nagaland, be included as respondent number 3. Stop. The applicant shall file amended course title on which the registry shall take necessary steps. Stop. Huh? You file amended petition,
Lordship, within a week.
amended petition within a week. Huh? And the registry shall do the necessary, do the needful stuff. With about this, IS stands disposed of.
Much obliged.
And in the main, when do we fix?
Lordship, it's fixed after 3 weeks, so it's coming on
Our
21st May.
Mikai Chai, and then Nana counsel for the petitioner, and Mrs. Merit, Nana PP for the state staff. Huh? In view of the order passing IA 14/2024, the petitioner shall file amended course title by including the victim as respondent number 3. Respondent number 3, huh? Stop. The list is matter after
2 weeks, Lordship.
LCR was received. The registry shall issue reminder for LCR. Huh? Stop. There is also interim.
Lordship, yes, Lordship.
Stop. Huh? List is matter after
2 weeks, Lordship.
3 weeks. Stop. In the meantime, the interim order pass earlier shall continue till the next date. Okay.
Much obliged, Lordship.
For motion, item numbers 31 and 32.
Lordship, here the respondent number 2, who was the engineer in chief NPWD, he has retired, Lordship. Therefore, we want to implement the present engineer-in-chief as respondent number 3.
Okay. Okay, heard Mr. Santiago, land counsel for the applicant. Petitioner, stop. Para. This is. This is an application under order 1, rule 10 within bracket 2 of the Civil Procedure Code 1908 for impleadment of Sri P. Imna Au, Engineer in Chief, NPWD, Nagaland, Kohima, in Kohima. He is in
COP contempt number 29/2023. In COP under bracket contempt number 29/2023, Lordship.
okay. Is the who retired? Respondent number 3.
Respondent number 2 has retired, Lordship.
2. Okay.
Yes, she
In place of the respondent number 2 who has retired from his services. Staff. The prayer for implement is allowed. Staff. The petitioner shall file amended course title within a week from today. Staff. By impleading the by inserting newly impleaded respondent number 3 in contempt number 63.
29.
So 29.
Civil original petition under bracket contempt number 29/2023.
29/2023. Stop. With the above this, IA stands allowed and disposed of.
Deeply obliged, Lordship. If the matter can be listed after 3
In
weeks,
the
Lordship.
main, then in the main. Okay. For Mr. Santiago, land counsel for the petitioner staff. In view of the order passed in IA number 63, 2024, the petitioner shall file amended course title by impleading the new by inserting the newly impleaded respondent number 3 within a week from today. Stop. And shall take steps upon the newly impleaded respondent number 3 by a registered post with AD within a week from today.
By registered post as well as by TASTI, Lordship.
As well as, okay. As well as?
By TASTI service.
Okay, by TASTI service. And file affidavit. And file affidavit after done with.
Yes. Lordship.
Affidavit to that effect.
Within 10 days, yes, Lordship.
Within 10 days from today. Start. List this matter after
3 weeks, Lordship.
3 weeks. Okay.
Deeply obliged. For admission, item number 3.
Lordship, in this matter, the matter was referred to the mediator. And the mediator has submitted the compromise report, Your Lordship. The settlement, the matter may be closed, but the
in terms of the settlement.
In terms of the settlement and the specific terms should be reflected in the order, Your Lordship. That is paragraph 1 of the page 2. Paragraph 1, which runs
Here,
Paragraph one of,
paragraph one of the settlement, your worship, that may be reflected in the judgment because in this case, your worship, the petitioner has now to pursue her pension. And since there has been some gap delay in the pensionary process, the AG may object. But here, the department has made clear.
paragraph one.
Yes, so paragraph one, if I may read, your worship.
Yes, which
This
one?
is the terms, these are the main terms. If
Yes.
this paragraph one, starting from Roman 1 till 7, sorry,
Okay,
page 4, this may be reflected in
okay,
the final order of this honorable court, so that
okay. Mr. Kampo Pogner, Land Council for
petitioner.
the petitioner. Stop. Also heard Mr. Moem Chen, Land Senior Government Advocate for the state respondent. Stop. Where is the order which, by which the it was direct for the
No, what?
settlement pro mediation?
This was on 21/11/2023.
Para.
21/11/2023. By order of the honorable court.
By an order dated para 21/11/2023, this court directed the secretary of the High Court Legal Services Committee, Kohima bench to appoint a mediator from the list of mediators and fix a date for their appearance. Stop. Thereafter, the party was directed to report before, just a minute. Not fixed, and directed the parties to report before the secretary of the Legal Services Committee, Kohima bench. Stop. It was further directed to the mediator to report about the outcome of the mediation process within a period of 6 weeks from the date of the said order. Stop. Para. Pursuant to the said direction.
Lordship, you will find in page one, or sitting, date of sitting, that is 29/11/2023. That is first sitting. Second sitting is
Mediator. Just a minute. Case number. Person to the same direction, the mediator, the mediation proceeding proceeded and set on in between 29/11/2023 to 15/4/2024. Set, okay. And settle the matter on 15/4/2024. And finally settled, settle the matter on 15/20/24 in presence of both the parties, staff. The mediated settlement agreement read as follows. Then you this from 1 to
Paragraph one only, paragraph one under.
1. Okay, 1. 1 has
One.
subclause.
Yeah, subclause it, up to subclause it.
1 till total paragraph 1. Okay. So what about this party 3? The parties further agree as follows. What is 3 is not
Three,
important.
it is not necessary, but the crux is in paragraph one.
1 only.
Yes,
Okay.
paragraph one. These are the main
Okay.
points under contention that has been settled by this.
Hmm.
The rest, there are some additions, but the issues involved have been settled under paragraph one, subclause 1 to 7. Lordship may say that the crux of the settlement is contained in paragraph 1, subclause 1 to 8.
Okay. So then inverted comma close, the both the parties agreed the above mediation agree the above mediation and put their respective signatures. Stop. By putting their respective signatures. Stop. Stop. In view of the above settlement, this matter stand closed in terms of the settlement, in terms of the above mediation settlements dated 15/4/2024.
2024, yes.
Stop. Anything else?
No, Your Lordship, only the reflection of that main portion
Yeah,
is,
it will be
yes,
reflected
because
only, with the above, this writ petition stands disposed of.
Your Lordship.
Okay.
For admission, item number 5.
Yes.
May I please, Your Lordship. Lordship, there is three respondents in this revision
How
petition.
many respondent?
Three.
Three.
Yes, one and two is represented by the Learned Council, and the third respondent is still not yet appeared. However, Your Lordship, even in the civil, before the civil judge, the case is proceeding ex parte regarding the respondent number three, Lordship.
Okay, just a minute. What is this matter about? Yes, what is this matter about?
Lordship, the petitioner filed a substitution application before the civil judge.
Okay.
Yes.
Yes.
So, Lordship,
It was not allowed.
yes, Lordship, because the civil judge did not consider the period which has been freezed by the Honorable Supreme Court due to COVID pandemic, Lordship. So I filed this petition. The court admitted during the hearing there was no question regarding the delay. However, when the court passed the order, my petition was dismissed, stating that I have delay more than 700 something days, Lordship. Both the defendant, as respondent, as well as the judge did not question regarding the delay when the hearing was taken up, Lordship. As such, I filed a
Have you
petition.
also filed condonation petition below before the trial court?
Lordship, I filed the petition. The court admitted my petition. There was no question regarding the delay. I was of the view that the court is taking into consideration regarding the period that has been freezed by.
No delay petition, no condonation petition was filed.
Yes, Lordship.
Okay.
As such, I was of the
And
view
at the
that.
time of
Yes,
then
at the time of hearing also, there was no question regarding the delay. However,
whether the respondent raised the question of
no,
delay?
Lordship, no, Lordship.
No.
Yes. So when my petition was dismissed by the order dated 4/8/2023, Lordship, I filed a petition, a condonation petition, explaining the court regarding
Let us
this.
see the impugn order.
Lord, it's on page 44 to 50.
Have you filed objection or
Yes, Lordship.
file objection also?
Yes, Lordship, I have.
Okay. Just a minute. Then you have received the copy of the affidavit.
Yes, Lordship.
Okay. Whether this matter requires hearing, can it be fixed for hearing then? If both are ready
Lordship, it can be disposed at this stage also?
at this stage?
Yes, Lordship.
You have an objection?
Yes, Lordship.
It needs
It's a
hearing then.
yes. I
You file
I beg your
objection.
pardon. Yes, I have in my affidavit, I have raised the objections, Lordship.
Hmm.
Lordship, here, my learned friend, the petitioner, has filed the IA for impleadment of the LRs as the plaintiff had deceased, Lordship. However, in that application, praying for impleadment of the LRs, there was no prayer for condonation. And Lordship, at the time of hearing, this was not the record speak for itself, Lordship. the
Have you
order-
filed objection in the trial court?
Yes, Lordship. Yes, Lordship. And
And have you received the objection? In the objection, have you raised this
Lordship, the
question of delay?
no, Lordship, I have not raised. The court
You did not
itself-
raise.
Lordship.
On what basis then? There was a delay.
Yes, Lordship. There was
But
a
then you
delay
also
of
did not raise.
753 days on the part of the petitioner. Rightly or wrongly, the court has held, the learned civil judge had held that there was a delay of 753 days, and therefore this IA was disposed accordingly. Lordship. 753 days. And only after this particular.
What generally the practice is in the trial court, where at the time of filing, whether is it the duty of the registry to check whether there is a delay or not? Or just one has
In
to,
my humble opinion, in some courts, the registry may be equipped with the knowledge to scrutinize that. However, in most cases, it may be the case where the judicial officers have to scrutinize this, because this is a question of law, Lordship, the Limitation Act, whether it comes under the period of limitation. This has
that
to
is
be-
at the time of filing of
Yes.
any application, one has to check
Lordship,
whether there is a delay or not.
Lordship, yes.
If the condonation petition has been
Yes.
filed or not. So what was the procedure
Lordship, when
at
I
the time of filing?
yes, when I filed the petition, that was not, there was no question regarding.
You
the
knew
delay.
that there was a delay.
No, Lordship, because the Honorable Supreme Court has phrased
Have you
it in-
mentioned that in the petition?
Lordship, no. However, that has been, the Honorable Supreme Court has already given the order, so I was of the view that I'm within the limitation if that period is being excluded, Lordship. So I filed the petition, the court admitted the petition without the question
No,
of delay.
my query is whether you have mentioned that since there is, although there is a delay, but then due to, because of the order passed by the Honorable Supreme Court, the delay, there is
No.
no delay. Have you mentioned that in your
Lordship,
petition?
in my.
I think we need to see all those things.
Lordship,
Uh,
my learned friend has enclosed all those in her.
What is your objection here?
Lordship, my very limited objection is that my learned friend is aggrieved with the fact that the IA for under Section 5 of the Limitation Act was not admitted, Lordship. But my humble contention is that this is a case of post-rationalization, Lordship. This is an afterthought. The IA, with a prayer to implead the LRs, was already dismissed, Lordship. And it was not a review petition or anything as such. It was a new petition under
No, when already dismissed means earlier also.
Lordship, yes. If I can.
Prior to the filing of this impleadment, earlier also dismissed.
Before the civil judge,
Hmm.
Lordship, the prayer for impleadment of the LRs was
Do we have the
dismissed.
record?
Lordship, it is, my learned friend has enclosed all the relevant documents in the revision petition, Lordship. It is
Okay.
so, Lordship, my learned friend had filed an IA for impleadment of the LRs, which was rightly or wrongly dismissed, Lordship. And after that, my learned friend preferred another, he had filed an IA under Section 5 of the Limitation Act, Lordship. So my humble contention is that the Section 5 application in such a backdrop, a Section 5 limitation in isolation, Lordship, cannot be sustained in law for the reason that an application under Order 22 Rule 9 is most clear on this. Lordship, the IA was disallowed, therefore, the LRs have not been impleaded. There is no longer a plaintiff in this case, and therefore, Lordship, the suit abates, Lordship. I will satisfy my Lordship with
I think deeper consideration. We need a longer hearing. No? So low points also involved. We'll fix for hearing. We'll fix a date. We'll have a comfortable hearing. Okay. Miss
Nagalisha, Lordship.
Land Council for the petitioner. I've also heard Mr. Land Council for the respondent.
Respondent number 1 and 2, my lord.
Respondent number 1.
1 and 2.
1 and 2.
1 and 2 only.
1 and 2. So other respondents are also there.
Yes, Lordship, respondent number 3.
Is this the 3 is the one to whom you have impleaded? No. This is different.
No, Lordship, the respondent number 3 is also the party in the main civil suit as well.
In the civil suit.
Yes.
Okay.
However, the case is proceeding without the appearance of respondent
And
number
in
3.
here you have taken steps.
Yes, I have served the.
So, but they are not appearing here also.
Yes, Lordship. Till today.
So till February, notice issued upon respondent number three. Three, return answer with remark insufficient address not found. Respondent number three, insufficient address. So you need to identify,
Yes, Lordship.
find out the proper address of respondent number three also.
Yes, Lordship.
And I think you need to take fresh steps to identify the proper address of respondent number three
Yes,
and to
Lordship.
take proper step.
Lordship.
Stop. The record reveals that the notice upon the respondent number three return answer with a posted remark insufficient address not insufficient address comma not found. What is this KTS? Not found. Stop. In view of the above, the Learned Counsel for the petitioner shall take identify the proper address of the respondent number three and take fresh steps within a period of a week from today. Stop. So, but then in absence of respondent number three, also can we fix for hearing?
Lordship, yes, it is
Okay.
very limited
Mm.
issue.
As the pleading in respect of the respondent, the petitioner and the respondent number one and two are completed, the Learned Counsel for the parties submits that the matter otherwise is ready for hearing. Stop. List this matter on. You want fixed date. So because in the meantime, she has to take fresh steps upon the respondent number three. Fix or after 4 weeks, we'll say.
Lordship, may I suggest 28 May?
28 May.
Tuesday, what
Okay.
Tuesday?
For hearing, huh? Okay. In the meantime, you take
Yes, Lord.
steps as early as possible.
Lordship, Lordship.
Lights well. For admission, item number 6.
May I please, Lordship.
Yes.
My lord, I'll be appearing for accused respondent number 3. Respondent number 3, man. And this is relating to restorations of the appeal.
Who
Appeal
was
was
the applicant in the IA?
CBI.
Yeah, I'm representing.
Is
Okay.
CBI counsel.
Hmm.
So I'll be appearing for respondent number 3. So I may be given 2 weeks time to file an objection
Okay.
against the restoration application.
Hard, Mr.
Ejo,
No, applicant.
Bandang Wapang.
Your name is also not reflected.
My lord, it's reflected. in
Bandang.
the notes. My name is
Bandang.
reflected.
Bandang,
Okay.
Bandang Wapang.
Yes.
Okay, Bandang, yes.
Yes, my lord.
Bandang, Babang.
And my name is not reflected.
Yes, it will. So you are
My-
counsel
yes,
for the CBI.
Yes, my lord.
Learned Counsel for the CBI. Also heard,
Mr. Ejo,
Aiju,
for
appearing on behalf of
respondent number 3.
the respondent number
3.
three.
My
And who appears on behalf of the respondent number 1 and 2?
My lord, here for respondent number 1,
Hmm.
prior to the dismissal of the appeal, Mr. P.P. Paul, who was appearing at one point of time, and Okavi and Associates, they
Okay,
were appearing on behalf of the respondent number 1. However, in respect of respondent number 2, he has been in absconder from the trial court. He's a proclaimed absconder.
okay,
Anyhow, before this honorable court, when the appeal was brought before this honorable court, notice was served. Thereafter, newspaper publication was also being made. But so far, no appearance has been made in this case, till date.
No one appears on
Yes.
behalf of the respondent number 1 and 2. Stop. Para. This is an application filed by the applicant under section 482 of the Criminal Procedure Code 1973, seeking for restoration of the criminal appeal number 03/2021, which was dismissed by an order dated 26/5/2023 for non-prosecution by the appellant. Stop. Issue notice.
My lord, just to highlight one fact concerning with the notice also in this case.
Since he has appeared.
Yes. So, custody service was made. And the report has already been filed by way of affidavit also.
So this is new only.
It's actually it was that particular case IA 25. It was a confirmation for delay. So by that time, notice was completed in respect of IA 25, and for 26, if this court feel that a fresh notice has to be issued, then I don't have any objection. But for formal notice to respondent number 1 will be take recorded. Will take a step against respondent 1 and 2.
One.
2 is
2 since you have taken there also.
yes.
Okay. So then returnable by
3 weeks,
3
madam.
weeks. Okay. Since Mr. Joe accepted notice
On behalf of
on
respondent
behalf of
three.
respondent number 3, no formal notice need be issued to the said respondent. You have received the copy also?
My lord.
Okay, start. The petitioner, the applicant shall take steps upon the respondent number 1. 1 also appear in the condonation petition also. Petition?
In continuation petition,
No,
they have not
okay.
appeared.
Take steps upon the respondent number 1 by a registered post with AD.
My lord, it will be more convenient if trustee service is
Okay.
allowed.
As well as Dusty
Yes.
will allow.
All right, all right.
Okay.
Correct.
By a registered post with AD within a week from today. Dusty is also, Dusty service is also allowed. Stop. So far as the respondent number 2 is concerned, the Ghana counsel for the applicant, some is threat. He is an absconder.
Yes, by the trial court, he was declared absconder.
Okay,
Yes.
absconder. So trial court is. This is offense was trial under what?
CCA.
Sorry.
PC under PCA.
Okay, PCA.
Yes.
Okay, absconder, huh? Even in the trial court. And absconder and the trial court has issued.
Thereafter, when this appeal was filed before the Honorable Court,
Hmm.
the dismiss appeal, 3K 2021,
Hmm.
notice was served. Thereafter, when the notice could not be served,
Now,
newspaper.
whether against this respondent number 2, whether any warrant was issued by the trial court?
I believe so, my lord.
Yes, standing warrant is
Standing warrant.
Okay. Okay, so far as the respondent number 2 is concerned, the Lane trial court has declared him as absconder and issued warrant against him.
Yes.
Okay, we'll do that. So, age grade, list is matter. So, just a minute, huh? The Lane counsel for the respondent number 3 prays for how much time?
2 weeks.
2 weeks time to file
Objection.
Objection, stop. No? As prayed, comma, list this matter because you have to take steps also.
Yes,
So that
yes.
will.
Limit it
stop.
then,
Three,
4 weeks.
Okay,
No,
list this matter after 4 weeks.
Much obliged.
much obliged.
For admission, item number 7.
Please, your lordship.
Yes. So,
Lordship.
what is this? Hmm?
Please, your lordship.
Yes, which one to be taken up first? IA. Yes, what is this?
Lordship,
IA is for?
there are two IA. IA is for substitution.
Okay,
Lordship, during the pendency of the RSA, the appellant, she expired. And subsequently, two IA has been filed. One I filed and another IA they filed for substitution. And thereafter, this court by
how many petitioner?
only one.
Okay,
So
you are for the
We vote for the petition, Lordship.
we have filed IA for substitution. He has also filed and I have also filed.
You are for
And for the appellant,
appellant number?
only sole appellant.
So,
Yes.
okay, and you are
I am for the IA 28 of 2023.
okay, that is different.
Yes, that
And
is different.
I'm for
You are
IA.
also for a appellant.
Yes, Lordship.
So for appellant, two advocates for different IAs.
Yes, Lordship.
Two substitution petition was filed. Because
Separate.
separate for substitution.
There's only one applicant for the RSA.
Just a minute. Yeah.
The main petition is RSA 1 of 2020. During the pendency, the appellant expired. Lordship. And,
Okay, so
and this court by order 19/6/23, in accordance to order rule 22, order 22, rule
we
5.
we are taking up which one? IA 28.
IA 28 and 48 both, Lordship.
Lordship, this court has directed the first appellate court to, this IA was remanded back to the first appellate court to decide who will be the legal representative of the appellant.
Okay, so whether,
So the record, I was told the record has come.
okay. So whether the appellate court has decided. This is IA. Okay. What was the direction of this court to the trial?
Lordship, that will be
Appellate
order
court.
dated 19/6/2023.
19.
19/06/2023.
In which IA?
Lordship, that will be in IA 28.
No,
The order is passed in order IA
in
28.
28, 19, that order is not available here. 19?
6/2023.
No. This is from 25/5 to
Lordship, I have
31/10.
provided.
19/6. This is in which IA?
First page this.
RSA1. This is not in IA. This is in RSA.
In the RSA.
I'm sorry, Lordship.
Hmm. Where is RSA? Okay. Yes, it is there in the RSA. What is the direction?
The first appellate court has directed, lordship. As that is the second para.
In the IA 28, the kindly read. Let us read.
This court, lordship has got it.
Third para.
This court therefore deems it appropriate to take recourse to the order 22, rule 5 of the CPC. So it says direct the learned principal district and session judge Dimapur, that is the first appellate court, to try the question as to which of the two applicants, that is the nephew in IA 28 or the son in IA 48, is the legal representative or legal heir of the deceased appellant. That will be the relevant portion of the motion. Accordingly, 4 months' time was granted,
Okay.
and it was extended from time to time.
So in compliance with that direction, the principal district
And sessions judge.
Lordship, if the report has been submitted, let us please furnish us a copy of the report so that we can examine the report, Lordship.
Yes, so we have received today only.
So therefore, the registry may be directed to provide us a copy of the report.
You haven't received.
No, lordship.
Okay.
The registry may be directed.
Are you entitled?
Lordship.
Lordship.
Okay. So then this will be in RSA only,
RSA.
not in R. Okay. Part. Okay, hard, Mr.
I, Jamir.
Land Council for the,
Also, I'm in IA 48.
no, in the RSA?
I'm still yet to be, because it depends on the report, your lordship. If
Okay, but then this report was,
Lordship, we are the one who filed RSA.
Lordship,
you are in the RSA?
I'm in the I'm the one who filed the RSA.
Okay.
Lordship, both of them are claiming on behalf of the appellant to be the legal representative.
Okay, but then
that has not been
only one has filed this RSA.
Yes, Lordship.
The other is also claiming that he has a right. You have also, you are also claiming that you have a right.
lordship.
Lordship.
Okay.
The appellant has expired. I'm appearing for the sole respondent, Lordship.
Okay. Just a minute. Okay. Hard, Mr.
Yeah, proceed, Lordship.
Land Council for the appellant. Also hard, Mr.
C.D. Runsu for the sole respondent.
Land Council for the sole respondent. Stop. Mr.
I, Jamir.
I, Zamir,
In IA 48, 2022.
profile IA 28.
48 of 2023.
You claim for? Your claim is that you are also?
I'm the son, so I should be substituted.
For his substitution in place of the
appellant.
Appellant is also present. Stop. The IA 28. Okay.
The one petitioner.
So here in the, as per the, in the report, so the learned appellate court has decided whether that he has decided. No one knows.
No, your lordship, that will be in the report. We'll have to go through the report.
The LCR is directed by this court on 19/6/2023 has been received. Staff. The registry shall furnish a copy of the LCR to the Land Council for the parties. Staff. So since then it has not been listed. 19/6.
No, lordship, it has been listed.
Listed from time to time.
IA was listed. So no order was passed in the RSA.
No, your lordship. Only the time was extended.
Okay, because the order is to be passed here already.
Only in our
Okay.
RSA.
Is prayed for by the Land Council for the parties. List is matter after?
Lordship, 3 weeks.
After 3 weeks. Okay, stop. In the IA also, do we need to pass order? No.
Lordship, similar order may be passed in IA. Similar order may be passed in IA.
Okay, here it was passed. Okay, then hard, huh? All of them. Hard Mr. So Land Council for that. This is in 28, okay. Applicant, huh? And Mr. TV Jamil Land Council for the applicant in IA Civil 48. And also, I've also heard Mr. So Land Council for the sole respondent. Stop. Para. The since just a minute. Okay. The report from the principal district and sessions judge regarding determination of the. We do not know this. This is the regarding determination of the question.
Determination of LR, Lordship.
Determination of LR. Determination of LR.
Yes. So, but then I haven't seen. Just now we have received.
Just in the order it may be reflected.
We'll say that LCR.
Received, yes. Lordship.
The report from the district and session judge has been received. Stop.
The registry may be directed to provide that may be reflected.
Okay, similar with that. The registry is directed to provide a copy of the report to the Land Council for the parties. Stop. List is matter after 3 weeks. Okay.
Obliged.
Alright, that is in board 28 and 48. Huh? Item number 16. RSA.
Notice, Your Lordship. Lordship, I beg to mention on behalf of legal Lordship.
Yes, counter not yet filed.
Lordship.
Miss. Okay, Land Council for the petitioner is present. Stop. And Miss.
Question.
Land Council.
Lordship, last chance may be given to the respondent party.
Last chance.
Yes.
Okay. Lord Council, for a learned government advocate, pray for further, how much time you said?
3 weeks, Lordship.
3 weeks time to file affidavit in opposition. Learned counsel for the petitioner submits that the state has taken enough time. So this may be treated as a last chance. Okay. The prayer is allowed, list this matter after 3 weeks. In the meantime, the state shall file their counter affidavit. The affidavit in opposition, okay.
Attached, Lordship.
From the supplementary cost list for admission, item number 34.
17. Okay.
In this case there was called for.
Yes, this 34 is.
2 years bail application. Your lordship granted interim protection. Therefore, case there was called for.
Yes.
The Lordship has received case diary and the FIR, Lordship. Lordship, on the ground that the petitioner was applicant was directed to appear before the IO in 10 days. Whereas on the ground that he has some medical difficulties, he could not appear, and his brother-in-law and mother-in-law, along with a written statement was sent to the IO, Lordship. However,
Sent to
the IO.
Hmm?
IO of the case, Lordship. IO of the case.
Investigation officer.
Investigation officer.
IO of the case.
Yes. Now the medical, if you look at the medical report, flag.
So the accused did not appear.
No,
Lordship.
Where he's stationed?
Gauhati, my lord.
Gauhati.
According, as per telephonic instruction, he had some ailments, so he could not appear, my lord.
There was a kind of medical certificate was also sent, Lordship. But seeing it, that is not very convincing, Lordship. If my lord may look at, I think it's the flag is.
So what is it? So what this shows, the CD? Have you seen the CD?
Yes, Lordship.
Is there anything against the accused?
Yes, Lordship. So now the IO wants his physical presence, Lordship.
His physical presence is necessary.
Yes.
IO said.
Yes. So it's kept pending for further investigation, Lordship.
What is this? This is FIR only.
One copy is FIR, and the other one is the case diary, Lordship. And now when we look on the ground that he has medical physical ailment, he said he could not come. But when we look at the medical certificate, the credibility is, I don't know whether that is very reliable, Lordship.
So, my lord, if possible, my lord, if another chance is given, I will personally instruct him to appear before the concerned IO. Or if he doesn't appear by the next date, my lord, my bail may be rejected, my lord. This is my prayer, my lord.
So in this CD, mother-in-law is required in the case.
No, Lordship,
not connected.
No.
Brother-in-law.
No.
accused has also given statement.
Written statement, Lordship.
So that was accepted by the IO. Or Mr. I. Chaudhary, Learned Counsel for the applicant. Also had Mr. K. Angami, Learned PP for the state. So, Mr. K. Angami produced the scanned copy of CD. And I perused the same stuff. Mr. Chaudhary, Learned Counsel for the petitioner submits that the accused applicant could not report the IO within 10 days as directed by this court on 16/4/2024 due to
Some ailments I have been informed about him. He had some ailments and he was also taking treatment in the hospital. Medical treatment.
his medical treatment for some ailment. However, he prays that one more chance may be given to the accused applicant to report and appear before the eye of the case. With the condition that in case the accused applicant failed to appear before the IO of the case within the given time, the bail, the interim anticipatory bail granted to the accused applicant shall be cancelled. Stop. So that can be granted.
Yes,
The prayers made by the land council for the petitioner has not been objected to by the landed PP. Stop. In view of the above, the accused applicant is directed to appear before directed to appear before the report before the eye of the case within 10 days.
Yes,
from today. Is directed. And then within 10 days, stop from today, stop. It is made clear that in the event of the accused applicant failed to appear before the eye of, failed to report before the eye of the case within 10 days from today, the interim anticipatory bail granted to the accused applicant on 16/4/2024 shall stand automatically cancelled without any further notice.
Yes. Madam, if date is fixed.
List this matter after.
Madam, can it be on 7th June? 7th June?
Okay.
7th June.
7th June is a month, Lordship.
No, actually, I have some
This is
cases.
May.
Yeah, this is May.
Because
After you may have to.
when, Madam,
First week of June, we'll say
Madam, can it be on 20th May, Madam? 20th May.
28.
28 May.
List this matter again on 28.
28 May. Obliged.
For orders, item number 17.
So Mr. Angami, you want to retain the CD? Okay. Okay, return the CD.
E and the FR.
And then on that day you produce the updated? Okay. The scanned CD be retained, let the scanned CD be retained by the line PP to be produced, the updated CD on the next date.
Lordship.
Okay, you produce updated CD on updated scanned CD on the next date. Okay. This is item? Okay.
Your Lordship, if this matter may be listed again on in the first week of June for admission hearing. First week of June
Okay,
for admission hearing.
admission hearing, okay. Mr.
Aaron Long for the
Line
petitioners.
counsel for the petition. Mr. Angami, you are for?
Respondent number 1.
Okay. I've also heard Mr. Angami for respondent appearing on behalf of respondent number 1. Mr.
LD Sankam for respondent number 7 and 8.
For respondent number 7 and 8, and
Lordship, I Jamir for respondent number 2.
I Jamir for respondent number 2. You are also appearing, Miss?
Lordship for in the Song Lordship.
Oh.
Respondent 4 and 9 Lordship.
Okay. For respondent number 4 and 9, stop. Kaba. Age prayed for by the Line Council for the parties. List this matter
3rd June.
on 3rd June for admission hearing.
On 10th June.
10th.
10th.
Okay.
10th June for admission hearing. Okay.
Obligement.
It is done.
For orders, item number 18.
So in 18 also, first step was to be taken. So
Item number 18.
no one appears on behalf. No one appears when the matter was called for. The case in adjourned. List this matter after 3 weeks. This is what. Restoration. Okay.